It is July 30th of 2026, and this is the Court Gallery. Today, Judge Hesselink gives a Canadian citizen a sobering lesson on international consequences after a DUI disrupts a vacation to the States. Then, Judge Stewart tries to get a clear factual basis for a confusing home invasion plea, but gets only frustration in return. Things escalate in Judge McNally's courtroom when a man on probation decides arguing is his best defense for multiple violations, and the judge's patience wears dangerously thin. And we end with a chilling case before Judge Stevens, where a defendant accused of stalking and making death threats learns his casual attitude comes with a hefty price increase. All that and more starts right now.
State of Michigan versus James Lesick, file 26-44591-SD.
Good morning, Your Honor. Maggie George, P85651, on behalf of James Lesick, who's appearing here via Zoom.
Thank you. I do see Mr. Lesick is with us. I have received an advanced behavior rehabilitation diagnostic report. I've also received defense counsel's sentencing memorandum. Mr. Fortier, did you have a chance to receive those documents as well?
I did, Your Honor.
All right. Today is the day set for sentencing. There was a plea back on June 25th to operating while intoxicated. Mr. Lesick, I'm going to listen to the recommendations of both of the attorneys, and then I'm going to give you an opportunity to address me and make any statements that you wish at that time, sir. Mr. Fortier, your comments?
So, Judge, I guess really the only things to point out, he's a Canadian citizen, so I think he's going to have a pretty hard time in the future after this particular offense. So I would leave it up, I guess, to the court if it wants to order probation, given the fact that he does live in Canada and probably won't be able to return to the U.S. Anytime soon. I do note that the evaluation kind of indicates essentially attending some of those educational programs. I guess it would be the Crime for Life program. There is a reimbursement request of $271 to the Michigan State Police. So I would ask that the court order that. And again, I would leave up to Your Honor whether or not you want to impose any sort of probation, given the fact that he doesn't live here. I would not have any specific objections if the court did not order probation. I would certainly find it to be appropriate, kind of based on the circumstances, if probation were ordered. But again, just given the fact that he's a Canadian citizen, I don't know how that would work in terms of monitoring him. So I'd leave that up to the court.
Thank you. Ms. George, allocution?
Your Honor, I don't want to belabor any of the points that you received in our memo. This is Mr. Lesick's first offense. He's 25 years old. He's gainfully employed in an industry that he's really passionate about as a hobby as well. This was something that he will not repeat. I believe, based on our conversations in the process of working through this, that he's absolutely learned from it, and he knows how bad it could have been. He knows how bad it could have been for him, for others. I just fully believe he won't repeat this conduct, and I understand that it's hard to figure out what to do because he does live in Canada. He has the support of his family. I've spoken with his dad extensively throughout this process. I do believe that he doesn't have a substance abuse problem, and that even if he were not placed on any term of probation, he would take this as a learning lesson and continue to make much, much better choices and not repeat this conduct.
Thank you, counsel. Mr. Lessig, is there anything that you want me to be aware of before I decide what to do?
Yeah, it was summed up pretty well. I just want to apologize to the community for my terrible choice I made. Every day has been a learning lesson since then. I've learned a lot. I continue to learn each day, and I will continue to learn in the future as well. And by no means will this happen again. I know I'm a Canadian citizen, but I frequently travel through Michigan down into the US, so you will not be seeing me again.
I appreciate those comments, Mr. Lessig. I am not by any means an expert on border law and whether or not you're going to be able to continue to travel into the United States. My guess is that you just made it a whole lot more difficult for yourself to do that, though. So this sentence is going to have a serious impact on you no matter what I do. And that's just one of the consequences that you're just going to have to live with, because there's nothing that I can do about that. The only other issue that I have is, let me start it by saying this. I was impressed by the letters that you got from your family and your friends. They all paint a great picture of who you are as a person. So I have no doubt that what you tell me you fully intend to do. My concern is that your high level of substance within your body at the time of this offense, you scored a 0.2. In Michigan, 0.08 is the legal limit for drunk driving. So you were 2.5 times the legal limit. I don't want to tell you that that's normal, because it's not. It's not near the highest I've ever seen, but it's well above just a casual drinker. So what I'm telling you is you've been drinking in a manner that has made your body make allowances for that much alcohol. Most people can't get to a 0.2 if they're not consistent hard drinkers. They would pass out before they got there. And you didn't pass out. You were out chasing storms at the time, or playing, enjoying friends. So all I'm really trying to tell you is the assessment doesn't think that you have a problem with alcohol, mostly because you don't think that you have a problem with alcohol. I'm telling you, I think that you do. I'm not going to change what I do today based on that, because this is your first offense. But if you are as smart as I think you are, you will take this information and you will process it, and you will change your drinking behavior. Most people that I talk to in your circumstance, I tell them, stop drinking. Don't try to limit it. Don't try to play with it. If you've gotten to this point and you've had this sanction against you, use this as a wake-up call to say, I need to change my behavior, not to not drive after drinking, but to not drink. Life is too good to mess it up with alcohol, and alcohol is insidious. It comes and gets you at the weakest point that you have when you don't even realize it's there. And so I don't want that for you, because you have a bright life in front of you. Having said all that, I'm going to have to trust you to do all this work, because you're a Canadian citizen. And if you were here in Michigan, I would put you on probation and I would require you to go to a bunch of things, but you can decide not to do any of that stuff simply by staying in Canada. And I don't have any authority over Canada. So it doesn't do me a whole lot of good to put you on probation. So I'm not going to do it. I am going to impose some fines and costs. You will owe those. If you ever do come back to Michigan, we can enforce those against you. But I'm going to trust that you will follow these recommendations simply because that's the best way to get you as a person down the road to old age safely for you and for everybody else. Does that make sense to you?
Yes, sir, Your Honor. I really appreciate
All right.
it.
So I'm not going to put you on probation. There are some mandatory fines and costs that I am going to impose. There's a $75 crime victim fee, a $50 justice assessment. There is restitution in the amount of $271. Court costs I'll reduce down to $200. The fine will be reduced to $100. And there's a local charge of $15. Let me add all of that up for you. It's a total of $711. Because there's no probation, I'm not going to do what I would normally do. And what I would normally do is require you to go to the substance abuse treatment that was recommended, such as an educational class. I would say that you had to go to some self-help meetings like AA or a similar program for alcoholism. I would say that there's no entrance into bars or places where alcohol is served by the glass. And I would have some alcohol testing done on you. Because you're a Canadian citizen, I'm not going to do any of those things. I'm simply letting you know that that's what should be done and that I would like you to involve yourself in all of those things as a result of this. Do you have any questions for me, sir?
No, Your Honor. I plan to attend some online meetings and cut out alcohol. I appreciate it.
All right. Ms. George, any questions that you have?
Just for clarity for my client, he can pay those fines either by mail or online?
We have a phone number that he can call to set up a payment plan or do that over the phone if he wishes. That area code 989. All right. Good luck to you, sir. I wish you well. That's all for today.
Thank you, Your Honor. Have a good day.
You too. State of Michigan versus Gerald Very, file 26-44593-SM, set for sentencing.
Good morning, Your Honor. Gabriel Matisse on behalf of Gerald Very, who's joining us by Zoom.
Do you see Mr. Very is with us? It's like we just got a copy of the substance use assessment yesterday, so I've not had a chance to read that. Let me do that now. All right, I've had a chance to go through the Catholic Human Services Substance Use Assessment Report provided by Michelle Klein after a review on July 7th. Mr. Very, I'm going to listen to the recommendations from both of the attorneys, and then I'm going to hear from you as to anything you want me to be aware of before I decide what to do. Mr. Fortier, your comments?
So, Judge, I think clearly the evaluation points out that there's a significant mental health issue going on, which seems to be the driver of his substance abuse issues. Looks like there is several prescription medications that he's currently taking to help manage his psychiatric conditions. And clearly, when you introduce other intoxicating substances into that fold, nothing good comes from that. I want to highlight for the court just kind of what's been going on since 2016. So in 2016, convicted of operating impaired. And I'm only going to bring up the substance abuse related offenses because there are some other ones. But then a 2017 conviction for operating while intoxicated. There is a 2019 conviction for delivery or manufacture of cocaine, heroin, or another narcotic. There is a conviction for conspiracy to deliver or manufacture cocaine, heroin, or another narcotic from the same year. A separate conviction for another delivery or manufacture of cocaine, heroin, or another narcotic. A 2019 conviction for prohibited use of chemical agent, a 2021 conviction for prohibited use of a chemical agent, a 2024 conviction for operating while impaired, third offense, and then we're here today. So I think it's pretty clear that there's a pattern of substance abuse related issues that he's facing. I think that the recommendations within the evaluation take that into account, and I do think that the recommendations that are made are appropriate, especially for him to remain abstinent from alcohol and any other intoxicating substances, utilizing his prescription medications as they are prescribed, to continue attending any psychiatric services through community mental health. I think that the ability for him to get some sort of sobriety housing would be good for him, as obviously the evaluation indicates might be some housing issues. So I think those things would be good for him. I would leave the issue of jail up to the court. My gut tells me that some jail would be appropriate to recommend, but I think given some of the concerns outlined within the evaluation, I think for him, treatment, whether that be inpatient or outpatient, seems to be the thing that would really drive this case. So I would ask that the court consider that. And that's it.
Thank you. Mr. Matisse, allocution?
Thank you, Your Honor. Mr. Berry does have mental health issues. He's discussed them with me, and he told me about what happened during this last period. He hears voices and he takes medication for it. And when his medication isn't sufficing or he runs out, he does things like use inhalants in order to stay level. He's talked to counselors about this. He and I have talked about it. Yeah, the inhalants do tremendous amounts of organic brain damage, and you just can't come back from that after a certain point. He understands that he needs to stay on top of having his medications there, working with professionals. But I believe that the evaluation really highlights that this is absolutely a mental health driven issue that causes him to want some sort of stability. And he's going the wrong direction for that, and he knows that there won't be any stability that comes from, any fluorohexanes that you can inhale, because those are very dangerous and they damage you. So he does have a history of this. He's quite a bit more stable now. He does have housing issues, and he's got quite a few struggles. But I think he understands that he needs to more proactively stay on top of working with people, getting help, and staying on top of making sure his medications do not run out, so he doesn't have a situation where he's trying to use some dangerous chemical substance in order to quiet down voices and feel level.
Thank you, Mr. Matisse. Mr. Berry, is there anything that you want to tell me?
As of right now, I am in the program called the Lion's Den in Roscommon, Michigan. They currently do not let me take any of my meds that I'm supposed to be taking, but I do plan to stay here as long as possible. If it becomes an issue, then I'll be leaving here and going to a rehab that does allow me to take my medication. Other than that, I plan to sign up for the Bear River housing whenever I leave here, and hopefully I can get into there. I just need to save up the money for the deposit that they require.
How long have you been in the Lion's Den?
Since the 13th.
How long do you anticipate staying there?
Just as long as I possibly can until the mental issues, until they say otherwise.
Do they have a certain program that you're in there, or is it kind of open-ended?
Well, in order to get the certificate, you got to stay here to 8 to 10 months. And then there is a staff portion of the program after that's a 10 months. So I haven't decided what I'm going to do yet, but I just wanted to get here before this court date, so that way the recommendation from the assessment said outpatient therapy, and I wanted to do one better and just get into some kind of treatment. And this was free and it was readily available.
Well, I'm very familiar with the Lion's Den. I am wholeheartedly in favor of their program there. I think they run a great program. I think they do a great service, and you would be well served by taking advantage for as long as possible with that program. I think they will work with you and with your physician if there's any medical treatment that is necessary. I know that they try to do it without that if at all possible, but I would encourage you to use this time with them very carefully and use it to the best of your ability. I think that's a great place for you to be, because otherwise you have a long history of making some really bad decisions. And at some point, a judge like me is going to say, we've tried the treatment program. We've tried everything else. Right now, it's more important to just keep people safe. So we're just going to warehouse you into jail. I don't want to have to do that. And because you're at the Lion's Den now, I'm not going to do that in this particular case. But you need to know that your history well warrants it. You've used up all of the do-overs and breaks that you're ever going to get. So take advantage of the program that you're in now long term. That's the only way that you're going to get better, is to take your medications and go through the treatment processes so you know how to comply with what you need to do. Does that make sense to you?
Yes, Your Honor. To reiterate, they do not allow my psychotropic drugs that I need for my mental health issues. So I'm going to stay here as long as I possibly can. But if it becomes an issue, I plan to go to Bear River or Sunrise or something, to a place where they do allow me to take those meds.
I hear what you're telling me, and I want you to hear what I'm telling you. If you can stay at Lion's Den, it would help you immensely.
Right.
So don't you have a preconceived idea of how you need to be treated. That's for the doctors and the experts to say. If the experts and doctors say you need to have medicine, great, then have that. But you can't self-diagnose and say, I want psychotropic medications, therefore I'm leaving this kind of treatment and going to get a different kind of treatment. You only do what the doctors tell you to do. And if the Lion's Den can help you without psychotropic medications, then let them help you for as long as humanly possible. You understand what I'm saying to you?
Yes, Your Honor.
All right. So I'm going to put you on probation for a little longer period of time because you've had a real struggle, and I want to make sure that you get the treatment that you're going to need. So I'm going to put you on probation for 9 months. There's a $270 probation oversight fee for that. There's a $75 crime victim fee, $50 justice assessment. Mr. Fortier, was there, I didn't hear any restitution request.
There wasn't an OWI, so there wouldn't be any.
All right, I didn't know if there's anything else, but all right, thank you. I'm going to minimize the fines and costs as much as I can. There's $200 court costs, $100 fine, a local charge of $15. Let me add up those requirements. Total of $710. You pay that over the course of probation. You may perform community service work in lieu of some of the fines and costs at the discretion of the probation department. I want you to enroll in and successfully complete the treatment program that you're in. So that would be the Lion's Den substance abuse treatment. You must also comply with all community mental health or other mental health treatment. That would include meds, counseling, and housing. And you must sign a release to probation so that they can monitor how you're doing on all of those programs. while you're on probation, there's to be no consumption or possession of alcohol or drugs, no entrance to do business where alcohol is served by the glass. That means no bars. Drug and alcohol testing at the discretion of the probation department. Because you're in treatment, I'm not going to impose any work camp or jail requirements. You must follow all substance abuse and community mental health treatment requirements. Do you have any questions, Mr. Very?
So the counseling that they offer here, is that enough, or do I have to get a hold
Yep.
of CMH?
Nope, nope. As long as you're doing what they require you to do. Once you're done with the Lions Den treatment program and you're out on your own, then you need to follow whatever community mental health or your other mental health treatment providers say for you to do, whether that's just medication or whether that's medication and counseling or whether that's inpatient that you need to go on a every once in a while basis. Whatever they say to do is what you need to do. Okay.
Yeah.
All right. Good luck to you, sir.
Thank you.
Next matter is the state of Michigan versus Matthew Wixon, file 26-44627-SD. Mr. Matisse.
Good morning, Your Honor. Gabriel Matisse on behalf of Matthew Wixon, who is participating by Zoom, and he's still muted. So, Matthew, there you go.
Oh, I was going to say, I think I just said it. Sorry.
All right. I do see Mr. Wixon is present. I have before me a request from the prosecutor's office to revoke bond. Mr. Matisse, have you received a copy of that motion?
Judge, I'm not aware of this motion at this time. I'm sorry. No, I'm not.
Looks like it was dated 7/8, so it should have been gone out. We received it July 8th as well. Mr. Fortier, do you have proof of service on Mr. Matisse or not?
The notice of hearing was sent by Miss Byrne on 7/8. Proof of service.
Yeah, I see a copy of that as well.
Yep, 7/8.
Art Wilcox, right here with Judge Hesselink.
Well, let me read it to you, Mr. Matisse, so that you can consult with your client about that. It says, on or about June 8th, the defendant was arrested for operating with a high BAC. Same date, he was arraigned and was granted conditional release. Bond conditions included daily PBTs. On or about June 30th, he appeared at the East Jordan Police Department and his PBT results were a .066 and a .068. He denied consuming alcohol. Paragraph 4 says that he's in a violation of his bond conditions and his bond should be revoked. And that asks the court to do that. There's a copy of a report from, looks like, East Jordan Police Department by reporting officer B. Cease, S-E-E-S-E. It says that at 7:30 a.m., Matthew Wixon took PBT at the East Jordan Police Department. Results were .066. Matthew stated he did not have any alcohol to drink. Stated he brushed his teeth and used Crest mouthwash before he came to the police department. Eyes were bloodshot. Did not smell any alcohol coming from him. At 7:45, so 15 minutes later, took another PBT and the results were a .068. Again, denied consuming any alcohol. Advised he was on bond from Otsego County. So,
I appreciate that, Judge.
proceed.
I did find that, Your Honor. For today's purposes, Judge, Mr. Wixon was going to plead on the underlying case. I don't know if this new bond violation would interfere with that or if that's going to change Mr. Fortier's offer.
It won't. If he's going to plead to the underlying offense, then we can dismiss the bond violation.
I appreciate that, Mr. Fortier. Mr. Wixon, is that what you'd like to do today? We talked about the offer. You would plead to the OWI first offense, and if you're willing to plead guilty to the bond violation, we can move forward with your plea today.
Absolutely.
So as I understood, Mr. Fortier, it was to dismiss the bond violation for a plea to OWI. Is that correct, Mr. Fortier?
Yes.
All right. So, Mr. Wixon, do you understand that the offer is to plead to operating while intoxicated, dismiss the bond violation, and I believe also dismiss the more serious operating with a high blood alcohol charge, which is what you're currently charged with? Is that your understanding?
Yes, sir.
Operating while intoxicated, the offer that's been made to you is a misdemeanor offense with a maximum penalty of 93 days and or a $500 fine. The current charge against you, operating with a high BAC, is a misdemeanor offense, but it has a much higher maximum possible penalty. Do you understand all of that?
Yes, sir.
If you were to take advantage of this offer today, you would not have a trial and you'd be giving up all of the procedures that offer protection at a trial. Do you understand that?
Yes, Your Honor.
Let me just finish making a note here. All right. If you wanted to take advantage of that offer, you'd be giving, as I said, you'd be giving up your right to have a trial. And these are the rights that you would have at a trial that you would be giving up. You'd have the right to have your attorney represent you at that trial. You could have a trial in front of a judge or a jury. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could testify or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent till proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. But if you entered a plea today, you'd be limited to asking for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, sir.
Understanding all of those rights, do you still wish to enter your plea today?
Yes, sir.
All right, I need to take some testimony from you, so would you raise your hand so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go ahead and put your hand down, sir. Other than this plea agreement, has anybody promised you anything to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right. The amended charge of operating while intoxicated reads as follows. It says that on or about June the 7th of 2026 in the city of Gaylord in Otsego County that you did operate a vehicle upon a highway, that is East Huron Street, while being under the influence of an intoxicating liquor or while having a blood alcohol content of 0.08 grams per milliliter of blood. Is that what happened?
Yes, sir.
What vehicle were you driving during this offense?
It was a black 2020 Hyundai Elantra.
And what did you have to drink before driving that Hyundai?
Some rum on the river.
How much?
Probably about a pint.
And did that amount of alcohol cause you to be under the influence of an alcoholic liquor?
Yes, sir.
Did you take any breath or blood tests after your contact with the police?
Yeah, we went right to the hospital and they drew blood.
Do you recall what the result of that was?
0.34.
That's
That
correct,
sound
Your Honor.
accurate, counsel?
That is
All right.
right, Your Honor.
Any other additional factual basis questions by either counsel?
No,
No,
Judge.
Your Honor.
Either counsel have any additional other promises, threats, or inducements not previously stated on the record?
No, Your Honor.
Both counsel believe I've complied with the court rule?
I do, Judge.
You have.
All right. I will accept the plea in this case. I do believe it was given knowingly, intelligently, and voluntarily based on the statements of the Mr. Wixon, based on my questioning. I believe he's given me a proper factual basis in that he told me that he drove a 2020 Hyundai Elantra after drinking a pint of rum, and that he was under the influence, and that he had a 0.34 blood alcohol content. Mr. Matisse, we're going to need a substance abuse assessment done in this matter.
Understood, Judge.
So Mr. Wixon, your attorney is going to assist you in getting a substance abuse assessment. We need to adjourn to get that before the sentencing, so we'll do that as quickly as possible. Let me get you a date for that.
Do September 3rd morning.
September 3rd at 9 a.m. Any conflicts with that?
No, Your Honor.
No, sir.
All right. Mr. Wixon, I would simply state that your blood alcohol in this case was extremely high. And the PBT results that I looked at that were dismissed against you were very disconcerting to me. What I'm trying to tell you is if there's any more of that, it will significantly impact your jail assessment that I do for sentencing. Do you understand what I'm saying to you?
Yes, sir.
All right. Get your assessment done. I'll see you on September the 3rd at 9 a.m.
Thank you, Your Honor.
There are a number of files to call next. They are file number 261845FH, 261844FH, 261843FH, and 262010FH. What the files all have in common is a caption, and the caption reads, People of State of Michigan versus Sierra Curtis Foster. Are you Miss Curtis Foster?
Yes, sir.
All right, and she's here along with her attorney, Miss Amy Lou Husted. She is the Deputy Director of the Public Defender's Office. Mr. Kerner is present. He's our elected prosecutor. I was given a number of documents, including an advice of rights form, appears to have been signed by Miss Curtis Foster, a plea agreement sheet signed by the attorneys as well as Miss Curtis Foster, and then Miss Husted, an amended information. Do you acknowledge receipt of the amended information?
I acknowledge receipt and waive formal reading, Your Honor.
Do you have it handy there so Miss Curtis Foster can review it if she needs to during the course of these proceedings?
Yes, Your Honor.
Thank you. With that then, Miss Curtis Foster, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. You may put your hand down, but try to keep your voice up for us. Are you on probation or parole in this court or any other court?
I'm not, Your Honor.
Other than the charges that bring us together today, do you have charges pending anywhere else?
I do not, Your Honor.
Thank you. Mr. Kerner, do you have terms for us?
I do, Your Honor. In file number 261845FH, the defendant will plead guilty to count 2 of the amended information, possession of methamphetamine, and an added count 4, home invasion, 3rd degree. The prosecution has no objection to treatment court if eligible and accepted. In turn, the prosecutor agrees to dismiss counts 1 and 3 in the entirety of case files 261844FH, 261843, and 262010FH. That might be a typo, Your Honor.
That's probably correct.
Okay.
That file wasn't on the docket this morning. I read it into the record because you listed it on your plea sheet.
Okay. All right.
Yeah, yes.
Okay. And the estimated guidelines are 0 to 17 months.
Thank you, Mr. Kerner. Ms. Husted, is that your understanding of the plea agreement?
It is, Your Honor.
Thank you, Mr. Kerner. Would you read those counts into the record, please?
Certainly, Your Honor. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and location described above, the defendant did count 2, controlled possession of methamphetamine, did knowingly or intentionally possess methamphetamine contrary to MCL 333.7403 2BI. This is a felony punishable up to 10 years and or $15,000. Count 4, home invasion, 3rd degree, did enter without permission a dwelling located at 1299 South Shiawassee, apartment 4B. While entering, present, or exiting the dwelling, did commit attempted resisting and obstructing a police officer, misdemeanor contrary to MCL 750110A4. This is a felony punished with 5 years and or $2,000 and is against the peace and dignity of the state of Michigan.
Mr. Kerner, does the factual for count 4 align with the charge, or would she be pleading to the greater on count 1 to get to the 4th? Well, actually, that's probably a question better left for Ms. Husted.
Your Honor, I believe that she'll be pleading to the greater.
Very well then.
I mean, her factual basis.
Yeah, I got you. Thank you. This is the element involves an R&O, and I didn't know if the charged R&O involves the home invasion.
Yes, in a way it does.
Well, I guess we'll find out, won't we?
Yes, Your Honor.
Ms. Curtis Foster, had you been paying attention?
Yes.
Well, let's go through the terms of the plea together so the record reflects both you and I understand them. I'm told you're willing to plead guilty to count 2 of the amended information, which is possession of methamphetamine. That's a felony punishable by up to 10 years imprisonment. Is that your understanding?
Yes, Your Honor.
I'm told you're also willing to plead guilty to an added count 4, which is home invasion 3rd degree. That's a felony punishable by up to 5 years imprisonment. Is that your understanding?
Yes, Your Honor.
Mr. Kerner estimates your sentencing guidelines to be at a minimum 0 to 17 months incarceration. Did you hear him say that?
Yes, Your Honor.
Did you hear him use the word estimate when he was discussing your sentencing guidelines?
Yes, Your Honor.
Well, that's important, Ms. Curtis Foster, because the court's going to score the accurate sentencing guidelines as we get close to your sentence date. My point is that if the court scores the guidelines differently than Mr. Kerner's estimate, you wouldn't be able to withdraw your plea on that issue. Do you understand that?
Yes, Your Honor.
Does that make sense to you?
Yes, Your Honor.
The next component of the plea is regarding treatment courts. The people have no objection to you coming into and being a participant in one of our treatment courts. You heard him say that.
Yes, Your Honor.
But it doesn't mean you automatically get to come in. There'll be a risk and needs assessment. I'll have to talk to my team about you. There'll be a pre-sentence investigation report that the court will use to help guide it. All of those things have yet to happen. So at this point, the court hasn't made a decision, Ms. Curtis Foster, whether or not you could come into the treatment court. It hasn't. But it will at some point during the proceedings when it has all the facts and circumstances behind it. But if for whatever reason the court declines treatment court status to you, you wouldn't be able to withdraw your plea on that issue either. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of the terms of the plea?
No, Your Honor.
And is that what you want to do?
Yes, Your Honor.
Would you be pleading guilty to possession of methamphetamine and home invasion 3rd degree because you are in fact guilty of committing those crimes?
Yes, Your Honor.
Has your attorney, Ms. Husted, left a final decision as to whether or not to plead guilty up to you?
Yes, Your Honor.
Has she talked to you about the different choices that you have to resolve these matters?
Yes, Your Honor.
Has she explained to you that you have a right to a jury trial and all that entails on each one of those files?
Yes, Your Honor.
Have you concluded then that the plea offer made by the people and accepted by your attorney on your behalf is in your own personal best interest to accept?
Yes, Your Honor.
Other than what was placed on the record here moments ago, Ms. Curtis Foster, has anybody made you any promises to get you to plead guilty today?
No, Your Honor.
Thank you. Ms. Husted, you aware of any promises not placed on the record?
No, Your Honor.
Mr. Kerner.
None, Your Honor.
Thank you both. Ms. Curtis Foster, has anybody threatened you or any members of your family to get you to plead guilty today?
No, Your Honor.
Do you understand, Ms. Curtis Foster, that once the court accepts your plea and finds you guilty, you give up or you waive your automatic right to appellate review? Do you understand that?
Yes, Your Honor.
If you wanted to appeal these proceedings to another court, that's fine, but you would have to go to that court and ask for permission or leave to appeal. Do you understand that?
Yes, Your Honor.
Do you have any questions so far?
I do not, Your Honor.
One of the forms presented to me by your attorney is captioned Advice of Rights. I mentioned it earlier. And when I review that form, I see down on the bottom of the form on the right-hand side somewhere a printed name, and it reads Sierra Curtis Foster, and above it there's a signature. Is that your signature?
Yes, Your Honor.
Did you read all the rights that are listed on that form before you signed it?
I did, Your Honor.
And before you signed the Advice of Rights form, did your attorney, Ms. Husted, did she make herself available to you to answer any questions you might have or address any concerns you may have about any of those rights?
She did, Your Honor.
Finally, Ms. Curtis Foster, before you signed the Advice of Rights form, did you, in your mind, knowingly and willingly waive those rights?
I did, Your Honor.
Do you have any questions of the court regarding your rights?
No, Your Honor.
Do you have any questions of the court regarding anything that touches and concerns the plea?
No, Your Honor.
Are you ready then to move forward?
Yes, Your Honor.
Very well, Ms. Curtis Foster. How do you plead to count 2 possession of methamphetamine?
Yes, Your Honor.
Guilty.
Guilty, sorry.
How do you plead to the added count 4, home invasion 3rd degree?
Guilty.
If we go back to the time and date set forth in the amended information, what happened on April 27th of the year 2026 that makes you guilty of those crimes? What did you do?
Your Honor, I stepped into the door after asking if I could charge my phone, and a couple of minutes after that, I had been asked to leave, and I did not leave right away when I should have.
Well, that just sounds like an unlawful entry to me. Did you commit some sort of crime or attempt to commit some kind of crime when you were in the dwelling?
No, Your Honor.
May I inquire, Your Honor?
You may.
Miss Curtis Foster, were you at Matthew Partaine's apartment on that day?
I was, Your Honor.
And he overdosed?
Yes.
And you were seeking help?
Yes.
And you went to a neighbor's house?
Correct.
And she opened the door, but she still had the chain across, correct?
Correct.
And you pushed through that?
I did.
And then once you were inside, she asked you to leave or told you to leave?
Correct.
And you didn't because you were trying to get assistance for Mr. Partain?
Correct.
I'm still not seeing it.
She admitted that she pushed her way in the house with the chain, through the chain.
You need the misdemeanor.
She had to have committed some kind of crime while she was inside. Otherwise, it's an illegal entry.
Okay. And did you know that, had you stopped at another house before to call the police?
After that.
It was after this one?
Yes.
Did you take anything while you were in their house?
I did not.
Were you attempting to avoid police contact? Is that the reason you did not stay at Mr. Partaine's residence?
I did not.
You did not attempt to avoid police contact?
No.
Did you have drugs on your person when you broke into that house?
I did.
Is that, no?
It does not.
Okay.
She has to have committed a misdemeanor, felony, attempted to do the same, or as the body of count 4, added count 4 says, commit an R&O while she's unlawfully within this dwelling place.
Are you sure this isn't the second house? This is the second house. Mm-hmm. Okay, so yeah. So you were attempting to avoid the police. Your Honor, just one moment. There was a little bit of confusion as to which, she was confused as to which house. There were 2 houses she went to that day. Miss Curtis Foster, the address 1299 apartment B4, that was the second house, correct?
Yes.
And when you went to that one, you were attempting to avoid the police. Correct. You had ran from the first house when the police arrived, and you were attempting to avoid them.
Correct.
Because you had drugs on your person.
Correct.
How are we?
So the factual is resisting obstructing while unlawfully in a dwelling home. Is that correct?
Correct.
Well, let's unpack that then, Ms. Curtis Foster. Where was this dwelling house?
The address, Your Honor, was 1299.
Was that in the city of Owasso?
Yes.
That's in Shiawassee County, correct?
Yes, Your Honor.
And that was not your house?
Correct, Your Honor.
And then you entered that home without the owner's consent?
Yes, Your Honor.
And you entered it by breaking through the door?
Yes, Your Honor.
And the person was in there, didn't want you there?
Correct, Your Honor.
Were you being pursued by law enforcement?
Yes, Your Honor.
And were they chasing you on foot? Were they in their vehicles?
On foot, Your Honor.
And did you know that they were police officers because they were wearing police officer uniforms and badges and equipment on them and things like that?
I did, Your Honor.
And were they giving you commands?
They were, yes,
They're
Your
telling
Honor.
you to stop or come here or freeze or
Yes,
something like that, and you obstructed and resisted by not complying with their lawful commands?
Yes, Your Honor.
And then your attorney inquired, said you had drugs on you at the time?
I did.
What kind of drugs did you have on you?
Methamphetamine.
And what was the quantity of drugs that you had on you that you say was methamphetamine? Do you recall?
Your Honor, I believe it was under the influence at the time, Your Honor.
No, the quantity, how much?
Your Honor, they didn't send it to the lab. We just have a true narc at this point. So I don't have a official weight. I'm looking to see if they listed I do not see an official weight listed in here, Your Honor.
Can you eyeball it?
I don't see anything where the officers weighed it, Your Honor.
And you don't recall the quantity of methamphetamine you had on your person? Was it under a gram, 5 grams, 10 grams, 100 grams?
Under a gram, Your Honor.
Under a gram. That's what I'm looking for. I'm just trying to get an idea. So not very much.
Correct, Your Honor.
But this was your methamphetamine?
Yes, Your
You
Honor.
knew that you had on your person methamphetamine?
Yes, Your
Is
Honor.
that a drug you intended to put in your system at some later time?
No, Your Honor.
You weren't going to use it?
Oh, yes, Your Honor.
Okay. Ms. Issa, do we have a factual basis?
We do, Your Honor.
Mr. Kerner, do we finally have a factual basis?
I think we do.
Ms. Issa, do you believe that the court's complied with the guilty plea provisions of Michigan Court Rule 6.302 subsections B through D of that court rule?
Yes, Your Honor.
Mr. Kerner, do you concur with Ms. Issa on that point?
I do.
The court does find you guilty, Ms. Curtis Foster, of possession of methamphetamine and home invasion 4th degree as set forth in the amended information. Let's check in, and your convictions are now made a part of the record of this court. Let's check in with Mr. Schmidt and see if we have a sentence date.
Yes, sir. It's going to be October 2nd, 2026, 8:38.
Good for you, Ms. Husted.
Yes, Your Honor.
Would you like to address bond?
Your Honor, Ms. Curtis Foster has been working very hard. She has been following pretrial services. We got her temporarily suspended from pretrial services so that she could go to inpatient at Sacred Heart, so that she could do a safe detox. So she has been off of the drugs and is going to outpatient treatment. She also has some children, Your Honor, small children. She has made every court appearance. We are asking that she be left out on bond.
Thank you, Mr. Kerner.
I'll take Ms. Houston at her word that she's been doing these things. If she's been being tested through pretrial, I have no.
I'm hearing that she's not.
Oh, I would request a test.
Yeah, I think that's fair. Ms. Curtis Foster, when was the last time you used?
I believe April 27th was my last use.
Okay, all right. If we had you test today, what would it show us?
Negative, Your Honor.
Okay. Well, I like to trust but verify. So I will make you a deal. If you give me a clean screen today, I will continue your bond. Is that fair?
Yes, Your Honor.
Very well then. Ms. Mariah is here to help you out with the drug screen. I'm going to assume that you're clean. And if you are, then I won't see you again today. However, you will be required to head over to the sheriff's department only to give them a DNA sample. It'll likely be a mouth swab. Will you do that for us?
Yes, Your Honor.
Secondly, you'll need to meet with an agent from the Michigan Department of Corrections. The agent's job is to prepare a pre-sentence investigation report. Please be honest and forthright during the interview process. If there's anything good you want me to know about you, let the agent know. Also, if you have treatment records, which you should, gather them. Give them to the probation agent so they can be included in the report and I can review them. Do you understand?
Yes, Your Honor.
Lastly, as you're working with Mariah, she'll likely be part of the assessment team that's going to give you a risk and needs assessment to determine whether or not you're eligible to come into one of our treatment courts. Be honest and forthright with her as well. Do you understand?
I do, Your Honor.
Do you have any questions?
No, Your Honor.
Thank you.
Charles Lamont Towns, 2625W83892232. Your name, sir? I placed you on probation on January 17 of 26. I took it under 771.1. Actually, Judge Kirsten did. I sentenced you on January 7 of 26. And you have a violation of probation. And the violation of probation alleges 3 different violations. Count 1. You failed to attend your scheduled probation visit on July 30 of 26. Do you understand the charge?
Yes, you said July what?
I'm sorry, July 10 of 26. Do you understand the charge? Yes. Count 2, that you failed to pay your fines and costs as ordered. Do you understand that charge?
Yes.
Count 3, that you failed to provide proof of completing your 8 hours of community service by February 15 of 26. Do you understand that charge?
Yes.
You plead guilty. If you're found guilty, that would be 3 different technical violations. You could have your 771 status revoked. The conviction could be entered, and you'd be subject to a jail term of at least 15 days. Do you understand that?
Yes.
I need you to sign, read, and understand the advice of rights.
Yes.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing or a trial. Do you understand that?
Yes.
All right. You have the right to a lawyer. We're glad to give you one at public expense. Would you like an attorney?
No.
Are you sure? I'm just asking. All right. So I'm going to ask you how you plead now. Did you sign and you understand all the rights, correct?
Yes,
All right, count one to the charge you failed to attend your scheduled probation visit on July 10 of 26. How do you plead?
guilty. I forgot about the Zoom call. That was,
Hang on.
but go ahead. Yeah.
Did you fail to attend that scheduled visit on that day?
Yes,
Can you call in Jessica Sadie? Count two that you failed to pay your fines and costs is ordered, balance owing 300. How do you plead?
yes.
How do you plead?
Guilty.
Did you fail to pay your fines and costs as ordered?
Guilty.
Did you fail to pay your fines and costs as ordered? You didn't pay your fines.
Yes, I didn't finish paying them. I didn't pay them all. I paid 500, I owe 300 more.
Count three.
Yes, so yes.
Count three that you failed to provide proof of completing 8 hours of community service by February 15 of 26. How do you plead?
Guilty.
Did you fail to provide proof of completing your community service by then?
I didn't, well, I can say guilty.
This is my question. Did you fail to?
Oh, yes.
You failed to provide proof of completing your community service by February 15th. Is that true or false?
True.
Anybody in the world force you to plead guilty?
No.
Please accept it. All three counts. What are you doing?
I completed everything.
I'm gonna go grab his file. I was bringing a different file in here, Judge.
I completed everything I was told to complete. I did,
What do you mean?
every program except I owe $300. I missed the, guilty.
Let's slow down a second.
Mhm.
You didn't show up for your reporting, right?
Yeah,
And I told you if you didn't have the money, I said to put you on a payment plan of 75 a week starting February 27th. Didn't I tell you if you didn't have the money to call the court, we'd go on Zoom or you can come in on or before the due date and I'd give you an extension?
correct.
Did I tell everybody?
Mhm.
So why didn't you do that?
I got a lot going on and it just skipped my mind. It's my fault. I paid 500 of the 800 and I completed every.
Okay,
program.
slow down.
Yep.
Don't get defensive with me.
I'm not getting defensive.
Why didn't you provide us with proof that you completed your community service by February 15th, which
I
is
didn't know
now,
I-
listen, which is now 5.5 months ago. Why didn't you do it? I mean, it's not like this sentence was harsh or anything.
No, it wasn't. It
Then
was,
why didn't you do it?
I completed the program, Your Honor. I didn't know that I had to bring paperwork. I told my probation officer, and the lady, kept in touch with each other. She didn't give me any paperwork. I completed at the victory. I completed community service, picking up the trash.
Slow down. Just don't get defensive with me. You seem like you want to argue with me. Maybe I'm wrong. Your name. Did you do, I know you did, so you're telling me he did the court work for her.
So taking a look here, yes, he completed the work program date and he did complete the anger management intake class. For the community service, I reached out to Christy at Victory Gym. She stated, yes, Charles completed 4 hours of community service. He set up many dates and times, had many no-call, no-shows. I will double check this afternoon when I get to the office, but he's only completed 4 hours. And then she later confirmed it was only the 4.
Can when you check back with her, she's, there's one time that I rescheduled.
Sure.
Yes. Can I actually, Judge, the email was on July 9th that I emailed her. So this was fairly recent.
3 weeks.
Thank you, please, Judge.
Sir. Settle down. Please. It was incumbent upon you to prove to us that you did community service. She's not a babysitter. She doesn't need to be calling up nonprofit organizations to verify that somebody completed their community service there because the defendant's telling her to. You should have got the proof from them and you should have had it in here 5.5 months ago. I don't understand why you're acting like you're picked on here.
Judge,
Who's this with you? Who's this?
Wife.
Judge, I could also know.
What do you do for a living?
I worked at Ford.
You got a great job.
I got a lot of bills.
We all got a lot of bills. I got a lot of bills. I mean,
And you make more than me too.
well, I'm sorry if you think that's unfair.
Yeah. I don't think it's unfair. I think it's the truth.
What's that have to do with anything?
You brought it up, not me. I didn't say anything. I didn't say
I am bring. All I told. Come on, you want to argue with me?
You got it.
Listen,
I felt.
I have 3 issues. One, you didn't report the probation.
Guilty.
You got to quit interrupting me, or I'm gonna lose my patience with you. I don't want to lose my patience up here. I'm too old to lose my patience. Would you please stop interrupting me? Please? I need a response from you. You don't want to respond?
Oh, yeah, yes, I was listening to you. My mind just, I'm not gonna interrupt you.
Thank you. You're making this so much worse than it needed to be. If you'd have just come in here with some humility and said, Judge, I don't know how I missed that Zoom. I don't know how I did. I apologize. And yes, I should have called the court and asked for an extension. And yes, even though I'm busy and even though I'm working hard and even though I've got a lot of bills, I'm responsible enough at the age of how old?
54.
At the age of 54 to make sure I got proof of my community service to my probation officer by February 15th. That's all you had to do. That's all you had to do. And now you're making this difficult for me because now I feel when somebody stands up and they get indignant that just failed to comply with 3 court orders and they're acting like we're picking on them, it makes me think now I got to be tough because I don't want to be tough. I'm going to be completely honest with you. I don't want to be tough up here. If I could sit here every single day and never send anybody to jail, I'd be the happiest judge in the country. But I don't want people arguing with me or showing the court, not me, showing the system disrespect and acting like it's our fault that you didn't get your community service done and provide proof of it by February 15th. I don't want anybody acting like it's our fault because you have a lot of bills that you didn't take 5 minutes to call the court and say, hey, can I speak to the judge on Zoom? He told me he would give me an extension anytime as long as I called on her before the due date. I don't know any judges who do that. Maybe they all do. I don't watch other judges. I don't care what they do. All I know is I tell every single person that. And now you come in here and act like I'm picking on you and she's picking on you and the Victory Gym has outdated records. Well, whose fault is that? Jeez, I don't get it anymore. There's nothing oppressive about this sentence here. I know how I sentence. There is absolutely nothing oppressive about the sentence. Do you want to say anything before I sentence you?
Yeah, I want to say, I don't know why it seemed like I'm on defense, but I have a good probation officer and I have no issues or problems with her. I don't think that I'm being picked on. I don't know if this is my tone or whatever, but she's been a good probation officer.
I know she is. She's
right.
really good.
And the Victory Gym, I just simply went and did what I was supposed to do. I didn't know that I was supposed to receive a copy of anything to bring it. I thought that they would put it to my probation officer. So I guess that's my misunderstanding. The last day that I did my 4 hours or whatever, she wasn't there. It was somebody else there taking her place. It was a guy there. So this is my first time doing that. I didn't know how to go. I didn't know I was supposed to get paperwork. I thought that she reported it to my probation officer. Like she had told me one time, the probation officer called her to see if I completed it. So I'm thinking they're communicating with each other. I didn't know that I needed a sheet of paper I didn't know that I needed something to bring to it. That's something I did not know. I didn't know that. I thought they communicated and, didn't know if it was done or not. And just the extra $300, it just slipped my mind. I could have called and asked for more time.
Fair enough. Now you're sounding like I would have expected you to sound the first time. How's he doing with everything?
The homework program's done, finished the anger management class, it's just the money, and the last remaining 4 hours of community service and anger club.
All right. Anything else? If I let you finish.
No, I've done all community service. I mean, if I gotta go get, or you get a sheet or you want me to get locked up while you call, I don't know, but
Nobody's locking anybody up. Stop. If I wanted to lock you up, I'd have done it 7 minutes ago. Wife, you seem like a very nice lady. Will you have a conversation with him when he leaves here, please?
Absolutely.
I'm gonna assess costs $50. You're gonna perform 16 hours of community service by, and I'm gonna give you, including by August 31, including any hours you've already done and you provide us with proof of. So if you're sure you got the 8, go back to them, get the 8, serve 8 more and have it done by August 31.
Excuse me, I didn't catch all of it.
You have proof that he's performed 4.
I have proof that he's performed 4.
So if no other proof is acquired, you have to provide proof that you've done 12 more hours, whether hours you've already done that they can verify, or new hours. I'll need proof that you have 12 more hours done, total of 16 hours by August 31, including those 4. I'm assess costs of 50. And then you and I are going to talk it out like men and figure out when you can pay this. If you need more time, I don't have a problem. Just show me a courtesy. How much, can you pay anything today?
No, I just.
Okay, fair enough. I'm not trying to pick on you. Just tell me when you can pay this. You get paid weekly?
Yes,
Do you want to pay weekly?
I try to pay 300 tomorrow.
I don't need you to try. I want to make sure you can pay, and I don't
I'll pay 300.
I don't need all. I don't need all 300 by tomorrow. If you want to pay it by tomorrow, I'll order you to pay it by tomorrow. If you want me to set you up on 50 a week, I'll set you up on 50 a week. You want to pay 50 a week?
Nah, I'm gonna put.
You can talk to your wife about it. You pay 50 per week, and I'll start that beginning on August the 3rd. If you want to pay it all tomorrow, God bless you. If you don't, that's fine. Just stick with that payment plan. If you don't have the money, no problem. Call the court. We'll go on Zoom. I'll give you an extension, okay?
All right, so just to keep it clear, so I gotta go back to Victory for. I know it's all together 16 hours, so I've done 8 already, so
Well, you have to get proof of the other 4. Right now, Victory Jim thinks you only did 4. If you get proof that you did 4 more, then you have to do, that's fine. You got to provide us with that proof and do 8 more by August 31. Okay? Good luck.
Thank you, appreciate it.
Is it Correa Michelle Jones?
Yes, Judge, she's here.
Is that you, ma'am? And hello. Oh, boy. This one goes on and on. This one. Okay. In 23 CR 2009, you are charged with on or about July 24th, 2023 in Jefferson County, Texas, committing the offense of theft. Paragraph 2 goes on to allege that you have 2 or more prior theft convictions, and that's out of County Criminal Court of Law 2 of Harris County, a district court out of Harris County, and the Orange County District Court. So paragraphs 1 and 2 constitute a state jail felony. When you steal a pack of gum, and if you're convicted of that, you could possibly be charged with a state jail felony just because you have 2 or more prior theft convictions. So, but it doesn't end there, because the indictment goes on to state that you have five prior state jail convictions of forgery in 1998 out of Harris County, forgery 1999 at Harris County District Court, fraudulent use of identifying information out of Harris County Court, fraudulent use of identifying information, a state jail felony out of Harris County in 2005, and also in March of 2005, another fraudulent use or possession of identification information. So you've got 6 more prior state jail convictions, and I think this enhances
The third degree, is my understanding.
the 3rd degree
Yes.
punishment. 2 or more. So this means at the end of the day, you're looking at no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. And you are not eligible for probation in front of a jury. If you tried the case and lost, you would be sent to prison. as the punishment. All right. So you understand what you're facing?
Yes.
Okay. And all of this out of a theft that's a value of less than $2,500, but prior to criminal history is a part of the equation in punishment. That's why I'm urging you, stop committing crimes. Stop. It just gets worse under law. You get more serious punishment. What are you going to do?
You're going to have to be placed on a trial.
Oh, okay.
Judge, there was a prior state jail offer. I am going to withdraw that offer until now she is subject to the enhancement.
Your Honor, the offer I have was 2 years TDC. That's a third degree. That's the offer I had. This is what I have written down. What's the offer you have?
2-year state jail, and it wasn't given by me. It was given by someone before me,
Right.
so I'm not sure.
Right.
But in the file, it had 2-year state jail.
Well,
There's, yeah.
so what?
So he's
what,
looking.
maybe.
So as of today, I'm willing to honor the offer that was placed by a previous prosecutor of 2-year state jail. If she doesn't take the 2-year state jail today, that offer is withdrawn and we're going with the enhancement.
I think we're still going to after a trial, Judge.
Okay, so that's what will be done. No deal. All right. Set it for trial. And we will move forward that way.
Thank you, Judge.
Okay. Just see. Zane Kimball. That's weird. Oh, I've got an add-on. Here. You're saying Kimball? That yes, yes, sir. Okay. Do you have an attorney?
Mr. Manage, I just told him I'm 7 12.
One month. So you have a GPS device? Is that what you have? An ankle monitor or something?
I believe. Condition.
Sir?
I just have one bond condition. No contact.
That's not what this says. I'm looking at a condition of bond signed by Justice of the Peace Benjamin Collins on February 12th of this year. It states, you must have a GPS ankle monitor, remain in Jefferson County, Texas, no contact with the victim. Is that what you have?
Yes, sir.
That's a condition of bond that was signed by Judge Collins on February 12th.
It's my first time hearing.
When were you arrested?
For this exactly.
About when?
So 4 or 5 months.
I mean, these are all dated February 12th, which would have been. You've been here before in May, right?
So. You told me then that I should have.
You're mumbling. I can't hear you.
You told me even then that I only had no contact with my mom.
You showed up first in court on May 28th. Would that be about right?
Yes, sir. Sounds.
That's on my notes.
Yeah.
Like Jeff.
So much.
You were ordered to hire an attorney or fill out paperwork for indigency. Did you hire an attorney?
No, sir. I just got my job.
Yeah, you have to speak up.
No, sir. I just got my job.
The state has filed a motion to increase your bond, stating that your bond is not sufficient. How many lawyers have you talked to?
Two.
Two?
Yes, sir.
In the last half year? I mean, right? This happened in February, so here we are in the end of July. And you've only spoken to two people. You're not trying hard enough. What kind of job do you have now?
I build data centers for JVC Manpower.
You have to speak up.
I build data centers for JVC Manpower.
When did you get that job?
Literally last month.
How much are they paying you for that?
18 an hour. Works at consistent 7 slows.
How much money do you have to hire a lawyer?
I ain't even not first check yet.
No. How much money do you have stored away somewhere? You don't have anything. Okay. So, okay. So you're 20 years old and you got nothing.
This is, I mean,
Well, whose back are you riding on? You're an adult, sir.
I have my own house and
Well, how'd you get those?
working.
Okay. Well,
I'm just,
where were you working?
I was a carpenter.
Well, when did you quit that job?
Right at the end of last summer.
A year ago? You've been out of work a year?
And then
You can't find a job as a carpenter in this area?
I've been kind of stuck in the car.
Oh,
And I only have a job.
okay. I'm looking at this affidavit for arrest. It is most disturbing. This says that the victim's ex-boyfriend, father of her child, had been calling her from restricted phones. While on the scene, speaking to the complainant, the victim, the police, you called. I guess not knowing the police were there. And they listened to the phone call. And then she spoke, the policeman stated that you were not to contact her further, or you would be charged with harassment.
Is this old?
You're going to interrupt me?
Sorry.
Or is that what you do? After the report was generated, she spoke with the victim, who said she wanted to pursue charges against you, and provided the police with screenshots of text messages between you and the victim. You, according to the police, stated multiple times that you would kill the victim on the screenshots, and told her you were going to go to the her family's members' houses, wait on them, and she would see what would happen. You stated you would kill everyone she loved. And according to the victim, you showed her a pistol on a FaceTime call and showed her it was loaded. So because of that intimidation, she's been staying with others and trying to keep you from locating her.
So
I'm not through, Mr. Interrupter. Well, what we have here is just not the victim, but a witness, the police officer. And so because of this disturbing behavior, you have been indicted on or about February, in February 25th of this year. It says that you, pursuant to a scheme of conduct directed at another person, the victim here, you knowingly engaged in conduct that would constitute an offense under the penal code, which is namely with intent to harass, annoy, alarm, abuse, torment, or embarrass the victim. You caused the telephone of the complainant to ring repeatedly, and the intent was to harass, annoy, alarm, or abuse, torment, or embarrass the victim. You sent repeated electronic communications to the victim in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend the person by sending multiple electronic texts stating that you would cause harm to her and her family. So the grand jury indicted you for that. This is a third-degree felony, which carries with it up to 10 years in prison. And the state has filed a motion stating your bond is too low and wants the bond to be increased and raised. What does that mean? It means that you're going to go to jail. You never completed an indigent form? I don't know what that was. A form that shows that you don't have enough money right now to hire a lawyer. So you need to file, we're going to give you one of those. You're going to sit over there, fill it out. I will review it and determine what happens next, huh?
That's all old stuff. So
not old to me.
Yeah, I'm sure.
I have the authority to increase the bond when I decide it's not enough. The bond is how much right now? 20,000. When was that assessed?
What do you mean? Like, when was it set?
Mm-hmm.
It was right after I got out of jail.
I'm sorry.
It was right when I got out of jail. That was my original name.
What was the date of that?
I have no idea.
You don't even know when you got out of jail? I would probably remember that. Unless you are in jail regularly.
No, I've never been in jail.
Okay. You don't know the date you left jail?
I was only in there for 27 hours.
For how long?
27 hours.
And when did you go in? What date?
You said
February?
February, yes, sir.
My information showed it was an out-of-county bond, Judge.
Yeah, if we do not have a copy of that bond, Judge, because it's an out-of-county bond.
And it's how much?
20,000.
20,000. Okay. What was the date of that bond? Do y'all know the date?
If I don't have a copy of the bond, Judge, I don't have that information.
That's probably the reason why he doesn't have the GPS device, because even though Judge Collins said it, and it's
This thing is a half a year. So these issues should have been addressed by now. This is a half a year old. Judge Collins, the justice of the peace here in this county. I tend to think that sometimes magistrates out of other counties don't appreciate fully some of the issues that are addressed in other counties when they set a bond. But I know most judges are pretty sensitive about what goes on, and especially in their own county. And this court, in reading all of this, deems that this bond is insufficient. And it's going to be increased because these are very disturbing allegations. And among other conditions of bond, you're going to have to have a GPS ankle monitor so I know where you are. If at any time the victim claims you have possibly stalked her or attempted to contact her, which would be inappropriate, you will remain in Jefferson County, Texas. Is that where you're going to work? Is that where you're going to work, in Jefferson County? You said you're getting a job.
I already have a job.
Let's go this way. Okay, you got a job. Where will you work? What county? Oh, okay, Jefferson County, right?
Yes, sir.
That's still in Jefferson County. And you must remain in Jefferson County. If you need to work outside the county, you need the court's permission. And as long as it's not far, I don't have a problem doing that. You cannot have anyone on your behalf or you contact the victim. These are very disturbing allegations. So first thing that we do is we worry about the victim's safety in light of the fact that you have been accused by the grand jury of a very disturbing set of circumstances. Fill out this indigent form and then we'll we'll come back to you in a minute. Let me get to some other things here while we're waiting on you, sir. Thank you. back to you, sir. Come on up. Mr. You can't go here. All right. So.
Sure, all.
Okay. You didn't complete this, sir. I need you to tell me what the total assets are. And there's a total monthly income and assets at the bottom that you did not complete. A total at the bottom. And your monthly expenses are hardly, it looks like $7,250 you're putting down. That's not the monthly expenses that you have claimed amount to about $1,400, not $7,250. Come on, you got to do the math properly. You don't try to trick the court here. We do that. Hey, that Lamar University and that Spindletop Museum got a great gift yesterday. I don't know if you heard about that.
Not a great thing.
Great gift. An original photograph of the Spindletop bursting forth in 1901 on the oil gusher. Original photograph. There's only apparently 2 of them that were taken. And that one that was given to Lamar has only been published once 125 years ago. And that original photograph is now in the hands of the Spindletop Museum, which is owned by Lamar University. It's part of the Lamar University. You know, the actual field, the oil field, is on West Port Arthur Road a little bit down the road, about 2 miles or so from Lamar. You know why they called it Spindletop? Because the trees, the trees that were surrounding the oil field grew. I don't know what, they didn't say what kind of trees they were, but the leaves looked like spindles. And it was, the trees were above, the field sinks as they took the oil out. The field sunk. And so the trees were above them, and they called it Spindletop from the way the trees appeared, the leaves of the trees surrounding the oil area. Interesting. I thought it was called that by some machinery part that was used, because the guy, the person who was the chief driller showed up with a new drill when that thing burst in January of 19. He had a new device and it apparently worked. Anthony Lucas was his name. And this shows you the right machinery for the right job. Right. Here you go. He's already sworn into this, but what you need to do, come here. Here, initial, where you made those changes, sir, just initial them here with your initials next to them, so that people know it wasn't tampered with after it was done. Okay. And you've tried to find a lawyer here? Yes, sir. What I'm going to do is appoint somebody to help you. Okay. and see what happens on that. I'm sorry.
Can I ask what my bond's gonna be? Can I ask what my bond's gonna be?
I'm. Would
It
you?
wasn't said. It wasn't said.
Oh,
It's correct, Judge. You didn't say it. You normally raise it, you double the amount. It was 20. But you did not actually state an amount.
do you have a GPS device and thing, Ola? Here's what I'm gonna do. I'm gonna leave it at 20. You have to have a GPS device on you. You will be at home confinement. You can't leave except to go to and from work, food, attorney, court, until this can get resolved, okay? Try to hire a lawyer if you want, but if you can, I'm gonna appoint one of the public defenders to assist you until such time you can get somebody hired.
You think I'll be able to bond out?
I'm sorry, you have soft voice.
You think I'll be able to bond out my voice?
He wants us to bond out in the morning.
His
but-
bond is the same.
Right.
I'm not changing
See
it.
that.
I'm not gonna change it.
Despite his statements, he has had repeated contact with the victim. I have evidence of that.
When was the last time you had contact with the victim?
Monday.
Okay, that's good.
Monday was it?
He has been unsuccessful in talking to her, but he's made multiple attempts to contact her, Judge.
What's the state asking for?
I would prefer that you do what you normally do, Judge, and raise his bond, because I had the witness here prepared to state everything I'm telling you. I advised her that that's what was done because you said you were raising the bond. I feel like it's appropriate. I have not gotten into the details about how much he's been doing. I keep hearing this man making statements that I believe are untrue. And we need to get his attention, and leaving it at the same amount is not going to work. In my opinion.
All right. Then I'm gonna raise the bond to 30,000. It's 20, just now 30.
Appreciate that, Rob.
Don't have any contact with the lady. Nor anyone on your behalf. Okay? All right.
Judge, yes.
Yeah. Well, you have to have a GPS device so we know until we can trust you that you're not going to have any contact with it. And apparently they're recording things, so I wouldn't call them. You got to deal with this responsibly. They're going to take you into custody until you can get that additional amount. Stay away from that lady.
Come up with another $1,000 and get a GPS tether, or sit your butt in jail. Those are your choices, ladies and gentlemen. Well, not yours, personal, but his. As we sit today, as he sits tonight in Beaumont County Jail. Feel bad for him, but sounds like he bought his own ticket there. Punched his own ticket, as they say. Ladies and gentlemen, thank you so much for hanging out with me tonight. I'm making it an early night because I've got lots of things to do. The puppies need me. I have friends who need me. And I just need to be done for a minute. Thank you so very much. There will be more where this came from. As always, I am your lone wolf Boosel. I put these things together every single day of the week. And there'll be another one tomorrow. Same wolf time, same wolf channel. Keep an eye out. And if you're not finding anything you like, look back through the catalog. We got a lot. The archive is huge now. The archive has become huge. Watch some of the old ones. We'll be back tomorrow. But for now, I have this little button I like to hit. I need to say thank you in this order to Spec, Tracy, Jerberg, Spec, and Rhonda Ann. Thank you all so very much for your amazing super chats. Let's see what everybody said. Spec said, love to use in all nuance. Love used. She did a dumb. Am I right? You're right. She did a dumb. And like the stream, give every bit of your extra monies to the stream. I support these words. I'm not going to insist on anything. I love you. I love you all the way you are. I appreciate all your support, however it may come. Thank you all just for being here, just for hanging out, just for chat. Chat is amazing. Everyone, thank you so much. Jamargarg says we have the utmost respects for Specs, and this is true. And Rhonda says that she's giving all that she has on her card. She'll put more money on her card tomorrow. Maybe she'll do something smart with it, like get a Big Mac. But if she's really smart, she'll buy something for her hubby and her kids and make them something nice for supper or something like that. I don't know. Being silly, come here and give me a super chat, though. I always appreciate it. Silliness is fine. Anyway, kids, I'm your lone Wafusel. The guy who puts these little compilations together. Hope that we all can come together and as a group, maybe learn a thing or two. Have an interesting look at some current events, some cautionary tales, straight from the gullet of court to the land. Man, these things are, it's interesting. Every single one is a story to itself and interesting every single time to me. But for now, I'm your lone wolf Oostel. I'm your host for these here little get-togethers, and I'm your curator for this here channel. And for now, I am out. And remember, only you can take a bite out of crime. Bye. Y'all are.